Hello, welcome to the County Court Bench. I am Jenny Lynn Lawrence, and I serve as the Montezuma County Court Judge, which is located in the 22nd Judicial District. As a county court judge, I preside over all types of cases, including petty offenses, misdemeanor trials, felony preliminary hearings, and protection order proceedings. Each year, a significant number of the cases I hear involve drunken driving allegations, with approximately 150 DUI and DWI cases filed in our county last year. The statistics in Colorado are even more alarming. Over 22,000 DUI and DWAI cases were filed and processed by Colorado courts in 2016. Yes, you heard that correctly. There were over 22,000 drinking and driving cases filed statewide in 2016. Therefore, as a county court judge, you'll want to quickly get up to speed on driving under the influence and driving while ability impaired laws and procedures, because a large number of these cases will appear on your docket immediately. But before we begin looking at the DUI statutes, I'd like to recommend a valuable resource that you will want to keep at your fingertips. Each year, Continuing Legal Education in Colorado produces and updates a Colorado DUI bench book that addresses all of the aspects of DUI cases. I cannot overstate the value of this resource. The complicated landscape of DUI law is constantly changing, and the DUI bench book is a great way to keep current on the law. As a judge, your initial involvement in a DUI case will occur at the first appearance. Depending on the policies of the law enforcement agency in your jurisdiction, the defendant's first appearance will either be in custody, on bond, or by summons. If the defendant appearing before you is in custody, you'll begin by reviewing the affidavit filed in support of the arrest for probable cause. Based on this information, you will provide the defendant with a Rule 5 advisement informing him or her of her rights and the potential penalties involved. Next, you'll set bond in accordance with the requirements of Colorado Revised Statute Section 16-4-105. In setting bond, the court can impose any condition on the defendant's conduct that will encourage them to appear in court, at the same time protecting the safety of the community. If the defendant had any prior convictions for drug or alcohol-related driving offense, you must order sobriety monitoring as a condition of bond. Defendants can seek relief from this condition by proving they are enrolled in a substance abuse treatment program, by proving to the court that public safety will not be endangered without sobriety monitoring, and finally, by proving that it would be in the best interest of justice. By the way, you can order sobriety monitoring even if this is the defendant's first drinking and driving offense. In general, I consider sobriety monitoring if the defendant posted an extremely high blood alcohol content reading or he or she displays other significant risk factors. In jurisdictions that offer pretrial services, you can order these services to ensure that sobriety monitoring is implemented and that the results are reported back to the court. If a district attorney or bonding commissioner believes that a defendant has breached one or more of the conditions of their bond, Colorado Revised Statute Section 16-4-109, subsection 4A, allows them to file a verified application with the court describing the facts of the alleged breach. In most instances, they will allege that the defendant has failed an alcohol or drug test. Based on the application, the court will issue a warrant to the defendant, thereafter scheduling a hearing on the bond commissioner's application without unnecessary delay. At that time, the court can determine whether additional conditions should be imposed on the bond to obtain the defendant's compliance. If the defendant is not in custody and is appearing after having posted bond, the court must provide a Rule 5 advisement and set appropriate bond conditions as previously addressed. Because of the public safety issues present in all DUI cases, it is important to establish a bond return schedule that brings defendants before the court as soon as possible. If a DUI defendant is appearing on a summons, you will use similar court procedures, including a Rule 5 advisement, and if appropriate, a bond may be set under the authority provided in Colorado Revised Statute Section 16 5-205. Again, if sobriety monitoring is necessary or appropriate, the court should impose a bond that has sobriety monitoring as a condition of release. Courts across the state employ a variety of docket management systems. If you serve in a smaller county such as mine, which employs only one county court judge, you can set the DUI and DWAI appearances in a manner that is most effective for your docket. If, however, you serve in a court with multiple county court judges, there may already be a system in place for setting cases, or you may have the freedom to establish your own. Typically, all DUI cases begin with a pretrial conference. Thereafter, cases typically divide into one of two categories: those that are resolved by a plea agreement and those that go to trial. We'll look at each type of scenario next. In all criminal cases, including DUIs, plea agreements are governed by Colorado Revised Statute Section 16-7-205 and Criminal Rule of Procedure 11. In DUI cases, a plea can be entered in writing or it can be made verbally on the record. In either case, it is important for the judge to make a clear record establishing that the defendant understands the nature of the charge, the elements of the offense, and other plea requirements. There is one reoccurring issue in DUI plea agreements that I'd like to bring to your attention. Whenever you review a DUI plea agreement, it is critical to accurately identify the number of prior convictions the defendant has had for drug or alcohol-related driving offenses. In Colorado Revised Statutes, Section 42-4-1307, subsection A, the Colorado legislature declared that every sentence handed down to a repeat DUI offender shall include a mandatory minimum period of imprisonment, as well as restrictions on where and how the sentence may be served. Prior misdemeanor convictions that trigger a mandatory minimum sentence include driving while ability impaired, driving under the influence per se, vehicular homicide, vehicular assault, aggravated driving with a revoked license, or driving under restraint that is alcohol-related. As discussed earlier, courts must confirm on the record that each defendant who enters a plea understands the potential punishment that can result from that plea. In DUI cases, to make a knowing and voluntary plea, defendants should know whether a prior drinking and driving conviction will lead to mandatory incarceration. You may be thinking, well, then someone should look it up. While that analysis may be correct, implementation is not always that easy. In most cases, prosecutors will rely solely on the NCIC or the CCIC reports to determine prior convictions. Consequently, the first time a municipal conviction might be identified to a county court is after probation identifies it during the drug and alcohol evaluation that is prepared for sentencing. To address this possibility during the plea process, you can decline to accept agreements that specify jail limits or caps. Rather, advise defendants that they will be sentenced based on the number of prior convictions for drug or alcohol-related driving offenses. Making a thorough record confirming that the defendant understands the amount of jail imposed will be based on the number of prior convictions established at sentencing is the best way to avoid plea withdrawals. Colorado Revised Statute Section 18-1-405 requires that all misdemeanor cases, including DUI cases, be tried within 6 months, subject to certain tolling and exceptions. The 6-month time frame for a DUI case begins when a defendant enters a not guilty plea. For cases that go to trial, your first step will be establishing a timeline for pretrial motions to be heard. The most common motions filed in a DUI case are defense requests to suppress evidence. DUI cases present various unique evidentiary issues, such as qualifications and foundation for expert witnesses, propriety of expert testimony, foundation for breath and blood tests, roadside sobriety tests, as well as statements and actions of the defendant. For scheduling purposes, DUI trials are usually 1 day in length. They can go longer depending on the number of witnesses called or if jury deliberations are extended. In general, though, DUI trials will be completed in 1 day. When a person is charged with DUI in Colorado, they can be charged under 2 separate statutes, namely DUI as well as DUI per se. The initial DUI is a subjective statute in which the defendant is alleged to have driven while their ability was impaired to a substantial degree. A blood test is not required to be convicted of this offense. DUI per se, on the other hand, is an objective standard in which the infraction is driving with a blood alcohol level of over 0.08%. Prosecutors can, and often do, charge defendants with both DUI and DUI per se charges for the same event. However, according to Colorado Revised Statute Section 42-4-1301 subsection 5, any sentence imposed for a conviction on both charges shall run concurrently. We are all relatively familiar with the blood alcohol content thresholds of 0.08 for DUI cases and 0.05 for DWAI cases. But how does that play out in a courtroom? Next, we'll look at some of the presumptions and inferences that are made with respect to various blood alcohol content readings. A defendant is entitled to a presumption that he or she was not under the influence if their BAC is less than 0.05. The prosecutor is entitled to a permissible inference that the defendant was impaired by alcohol if the defendant's BAC is in excess of 0.05 but less than 0.08. The prosecutor is entitled to a permissible inference that the defendant was under the influence of alcohol if the defendant's BAC registers over 0.08. With respect to driving under the influence of drugs, the prosecutor is entitled to a permissible inference that the defendant was under the influence if the defendant's blood tested at 5 nanograms or higher of THC per milliliter in whole blood. DUI and DWI cases are not exclusively determined by blood alcohol content levels. How those results were obtained, both with respect to testing instruments and procedures, are routinely challenged in court. By statute, courts shall take judicial notice of the methods of testing used to obtain a person's alcohol or drug levels, in addition to the design and operation of devices certified by the Colorado Department of Public Health. Let's take a look at testing procedures. Driving in Colorado is a statutory privilege, not a right. Under the authority of Colorado Revised Statute Section 42-4-1301 subsection 6D, a party's refusal to take an express consent test is admissible into evidence at trial, and the refusal is not subject to a privilege against self-incrimination. Under the authority of Colorado Revised Statute Section 42-4-1301 subsection 6E, evidence obtained through an involuntary blood test shall be admissible in DUI, DUI per se, DWAI, and UDD cases. Strict compliance with the rules and regulations prescribed by the Department of Public Health with regard to a test is not a prerequisite for the admissibility of test results, unless the court determines that the failure impaired the validity and reliability of the test. Rather, any variance from the rules and standards goes to the weight of the evidence. Testimony by a law enforcement officer who witnessed a blood draw conducted by a person the officer believed was authorized to conduct the draw is sufficient to admit test results. Testimony of the person who actually drew the blood is not required. And finally, preliminary screening tests for alcohol, such as those provided by small handheld PBTs, or portable breath test devices, are not admissible at trial. As we discussed in the plea section of this course, if a defendant has one or more prior DUI convictions on their record, he or she will face a mandatory minimum sentence. Courts are obligated to impose a sentence based on the actual number of prior convictions. In addition to the number of previous DUI or DWAI convictions affecting sentencing, courts must also consider information described in a drug and alcohol evaluation. By statute, this evaluation must contain the defendant's prior traffic record, characteristics, and history of alcohol or drug problems, and amenability to rehabilitation. In most, if not all jurisdictions, probation will perform the required drug and alcohol evaluation following an entry of plea or an adjudication of guilt. The evaluation will include a comprehensive review of the defendant's traffic history, including a search of each municipal database in which a defendant has lived to ascertain if he or she had any prior municipal drug or alcohol-related driving convictions. As we discussed earlier, this search is in addition to the NCIC and the CCIC reports that the prosecution may have run following the defendant's arrest. This additional search can identify a drug or alcohol-related driving conviction to which the prosecutor was unaware. If there is a discrepancy in the number of prior convictions, Colorado Revised Statute, Section 42-4-1307, subsection 9B1, provides a framework by which the prosecutor and the defendant can establish the number of prior convictions for sentencing purposes. The prosecutor and defendant can stipulate to the existence of the prior convictions. However, the parties cannot, in good faith, stipulate to fewer prior convictions than actually exist. The prosecutor can present to the court a copy of the person's driving record provided by the Department of Revenue or similar agency with reference to the convictions, or the prosecutor can present an authenticated copy of the record from the previous convicting jurisdiction. Colorado Revised Statute, Section 42-4-1307, subsection 9B2, prohibits courts from proceeding to sentencing without one of these three proofs being satisfied. If probation identifies prior convictions to which the parties do not stipulate and for which the prosecutor does not offer adequate proof, sentencing must either be continued to allow the prosecutor to obtain adequate proof, or in the alternative, the prosecutor must make a record that no such proof exists. At that point, you can proceed to sentencing without counting the unprovable prior conviction. If a case is decided by a jury trial rather than by plea agreement, and the defendant elects to take an appeal, the defendant may ask the county court to stay execution of the sentence until the appeal is heard. In People v. Steen, the Colorado Supreme Court held that upon a defendant's request, the county court must stay both the jail and probation portions of a DUI, DWAI sentence pending appeal. However, the county court can require that the defendant post bail if jail time was levied, or require the defendant to post a bond to cover any fines and costs that were imposed. Another issue that frequently appears involves probation revocation requests. Because probation is mandatory in most DUI cases, there is a good chance that you will see some DUI probation revocations during your time on the bench. Colorado Revised Statute, Section 1611-205, governs probation revocation proceedings. If a complaint is filed to revoke probation, it must contain the name of the probationer and a statement describing the alleged violation, including the date and approximate location of the alleged violation. The defendant may appear before you either by summons or pursuant to an arrest warrant. If the defendant is in custody, the defendant must be advised of his or her rights, and if the defendant remains in custody, a hearing on the revocation must be held within 14 days of arrest. At a revocation hearing, the prosecutor has the burden of proof but must only prove the violation by a preponderance of the evidence. The rules of evidence are relaxed, and the court can take judicial notice of the contents of the file for that case or any other matter subject to Rule 201. Another significant difference between a trial and a probation revocation hearing is that the prosecutor can call the defendant as a witness at the revocation hearing. Although a defendant may assert his or her Fifth Amendment right to not incriminate himself or herself, the refusal to answer questions can be used against them in the revocation decision. With respect to the revocation request, the court will consider the following factors: the nature of the violation, the report or testimony of probation, the impact on public safety, the person's progress in alcohol or substance abuse treatment, and any other information relevant to the defendant complying with probation. If, after hearing the testimony, you determine that a defendant's probation should be revoked, the court can impose any sentence or grant any new probation as the court might have originally imposed. This includes any part or all of the jail time suspended under Colorado Revised Statute Section 42-4-1307, subsection 7C. No discussion of DUI cases would be complete without a brief mention of DUI treatment courts, which are now offered in many Colorado jurisdictions. In general, DUI courts were modeled after drug courts, in which participants receive more intensive case management and closer court contact in an effort to recognize and resolve underlying addiction problems. DUI courts are designed for high-level offenders who find themselves entangled in the criminal justice system because of addiction. They are not appropriate for low-level offenders who may have made a poor decision to drink and drive, but are not addicted to alcohol or drugs. Again, welcome to the bench, and thank you for watching this video. In all probability, a large percentage of your caseload will involve handling DUI and DWAI cases. Staying current with the law, as well as the technologies used to process these cases, will go a long way in helping you manage your caseload. Good luck.